Welcome to CCTV and the League of Women Voters of Marion and Polk Counties presentation of the 7 state ballot measures. Presenters today are myself, Diana Bodker, and Bernadine Anderson. The League has a long, proud history in Oregon and the United States. We started in 1920 in anticipation of the passage of the 19th Amendment, allowing women the right to vote. From the very beginning, our nonpartisan mission was to foster education in citizenship and support improved legislation. We greatly appreciate the opportunity to share this important information so that you, the voter, can make informed decisions. We will address each measure in order, and we may have some questions from our audience that is with us here today.
In this November 2014 election, there are 7 state ballot measures. 2 measures, 86 and 87, were referred to the voters by the 2014 Oregon legislature. The legislature must refer measures to the people for constitutional amendments, tax levies, and bond measures. Both houses of the legislature must approve a referral, and the governor does not have the authority to veto it. Both measures 86 and 87 would amend the Oregon Constitution. Measure 88 is a referendum. Citizens who have a concern over a non-emergency bill passed by the legislature and either signed into law by the governor or enacted after the governor's deadline for signing or vetoing a bill may file a petition for a referendum. 4 other measures also qualified for this election by initiative petition. Of these, one, number 89, is a proposed constitutional amendment, and 90, 91, and 92 would revise state statutes.
Reports on each measure were written by League members who researched each measure and interviewed subject matter experts, including sponsors, opponents of the measure, legislators, or legislative staff. League researchers and editors tried to verify all the factual statements in our explanations. We have made every effort to ensure that our reports are balanced, accurate, and fair. We hope these reports will give you, the voters, the information you need to make an informed vote.
So let's begin with Measure 86, the Oregon Opportunity Fund. This amends the Constitution. It requires the creation of a fund for Oregonians pursuing post-secondary education. It authorizes state indebtedness to finance this fund. As a referral, this measure is a constitutional amendment referred by voters to the 2013 Oregon legislature with a vote of 35 to 25 in the House and a vote of 20 to 10 in the Senate. The Oregon Financial Estimate Committee estimates no financial impact on either state or local government expenditures or revenues. However, the full faith and taxing power of the state of Oregon must be pledged to repay the bonds. The probable results of the yes vote. If this measure passes, the Oregon Constitution will be amended to require the legislature to establish a permanent Student Opportunity Fund. Income from the fund would provide financial aid for Oregonians pursuing post-secondary education, including career training. The measure authorizes the state to incur debt to finance this fund. The probable results of a no vote. If this measure fails, the Oregon Constitution will not be amended to extend credit and incur debt to create a dedicated fund to provide financial aid for Oregon students pursuing post-secondary education and career training. Some background for you. Oregon is projected to have 694,000 job openings between 2010 and 2020. 70% will require more education than a high school diploma. State economics depends on having skilled workers, attracting employers, and well-paying jobs. In recent years, post-secondary tuition costs have been rising nationwide as state legislators are providing less financial support to public colleges. This trend is evident in Oregon, where the cost to students and their families for a university education rose 50% over a recent 8-year period, with student loan debt following suit. For low and middle income students, Oregon awards about 1/3 of the national average for student aid. The current Oregon Opportunity Grant funds 1 out of 5 eligible applicants. There's no guarantee of funding from year to year. Funding for the current Oregon Opportunity Grant student assistance is allocated for general fund revenues every 2 years. The grant funding must compete with multiple state needs such as public safety, K-12 education, and health services. The state constitution allows for bond financing to pay for construction and upgrades of tangible assets, including buildings, prisons, energy projects, bridges, and roads. Bonds are sold to raise immediate capital, and the state takes on the obligation to repay the bonds over time at a fixed interest rate.
So I have a question is, what happens if this measure passes?
Well, if the measure passes, the proposal states that it gives the legislature permission to sell bonds to create a permanent growing education endowment called the Student Opportunity Fund. Initial fund capital from the bonds would be invested, and the endowment would be expected to grow over time. Earnings would be used exclusively for Oregon students pursuing post-secondary education, and that includes career training. The legislature could also vote to directly appropriate monies into the fund, and gifts from any source could also be deposited in the fund. The legislature would decide the specifics of the Opportunity Fund, when and how much bond indebtedness to authorize, whether or how much general fund appropriations to add, and how to structure the student assistance to anticipate Oregon's employment needs. This capital raised by this fund bonds would not be spent for student assistance. The Oregon Investment Council would invest the fund. And the Oregon Investment Council invests all of state of Oregon funds, and this includes Oregon Public Employees Retirement Fund, the State Accident Insurance Fund, for example. Only the earnings from the fund would be distributed to student aid. As with other general obligation funds, general fund debt service budget would be used to repay principal and interest on the bonds. The measure is not clear as to when the first scholarships would be issued. The endowment would grow from the earnings retained and are not spent on scholarships. Over the 30-year term of the bonds, State Treasurer Ted Wheeler projects that for each $100 million in fund bonds that Oregon issues, the fund would distribute scholarships from $5 to $8 million per year. Projections are based on 30-year bonds issued at a 4.5% interest rate and other investments with an average of 7% annual return, and student aid limited to a maximum of 5% of that fund. The fund is locked and cannot be appropriated by the legislature for any other purposes. The only exception would be if the governor declares an emergency and 4/5 of each state house votes to use the money for any lawful purpose, provided they can also have a plan to repay that fund. Now, we want to hear what supporters of this measure say, and they say it will make our state more economically competitive by contributing to the quality of our workplace and connecting Oregonians with the education and skill-based training employers require. They also say that it will increase funding for student financial aid, provide that aid on a more consistent basis, reduce student debt, and enhance opportunities for vocational and technical training. And it does not raise taxes. It merely gives the legislature improved financial options to make better use of the resources they already have. No guarantees will be made by the state regarding benefits or rates of return. The state's Financial Estimate Commission ruled that Measure 86 has no financial impact on the state. And lastly, if Oregon had established the Measure 86 proposed 30 years ago, seeded the fund with $100 million in bonds, and received the same interest as that earned by PERS Fund, today it would be providing $474 million while providing $351 million in student aid over the 30 years. So let's look at the opponents. They say that the ACT college admissions tests, only 30% of Oregon's 2014 high school graduates are deemed ready for college. Before we authorize more spending on higher education, we should find ways for our public school system to prepare college-bound students to actually succeed there. They also say bonds authorized by Measure 86 will not be paid off by investment earnings or by the students who benefit from them, but by Oregon taxpayers through the state general fund. Tax money that would not be available to fund K-12, prisons, or social services. Additionally, support for higher education should be made directly by the legislature in the budget process. The $6 million annual bond repayment on the fund would be better spent on financial support to Oregon's colleges and universities. Measure 86 bond funding for the Opportunity Fund in many ways circumvents some state budget setting priorities. That was Measure 86.
State of Oregon, Measure 87. It allows judges to work in other branches of state government. The official title amends the Constitution, permitting employment of state judges by National Guard, the military service, and state public universities, teaching. This measure is a constitutional amendment referred to the voters by the 2014 Oregon legislature with a vote of 51 yes votes and 7 no votes in the House and a vote of 29 yes votes and 0 no votes in the Senate. The financial impact. There is no financial effect on either state or local government expenditures or revenues. The probable results of a yes vote. If this measure passes, it would allow state court judges to be paid to teach at public universities or work in the Oregon National Guard. Probable results of a no vote. If this measure fails, Oregon law will retain the current constitutional restriction that persons employed by one branch of the state government, in this case the judiciary, may not also serve in a second branch. You have a question?
Yeah. Why did this idea come up for a ballot measure?
The background is that the Oregon Constitution, under its separation of powers clause, does not allow people to serve in more than one branch of the government at the same time. The separation of powers clause refers to the division of government responsibilities into distinct branches to limit any one branch from exercising the core functions of another. The intent is to prevent the concentration of power and provide for checks and balances. There is less concern regarding conflict of interest arising if a judge were teaching at a public university or serving in the National Guard. If such a court case arose, it could be assigned to a different judge. There are 3 law schools in Oregon. Currently, judges may teach at either private law school, Lewis and Clark or Willamette, but may not be paid to teach at the University of Oregon Law School because of the constitutional clause. A judge may volunteer to teach at the University of Oregon without pay, however. The legislature endorsed a referral on this topic in 2013, but that bill included reference to the State Board of Higher Education as the employing entity for the public universities. The legislature subsequently changed that governing structure, which made the 2013 language obsolete. The prohibition on judges being employed in the Oregon National Guard has not been tested in the legal system, but would likely be interpreted as contrary to the separation of powers clause. The proposal. Ballot Measure 87 would amend the Constitution to allow state court judges to be employed but for the purpose of teaching at public universities and to receive compensation for performing military service in the Oregon National Guard. Currently, Article 3, Section 1 of the Oregon Constitution, Separation of Powers Clause, prohibits persons from serving in more than one branch of government at the same time. As one result of this prohibition, state court judges may not be employed as teachers at institutions of public education. Article 2, Section 10 of the Oregon Constitution further prohibits state court judges from receiving compensation for performing military service. Ballot Measure 87 removes reference to the State Board of Higher Education to reflect the current structure due to recent legislative changes, and also rescinds Senate Joint Resolution 34 from 2013, which referred to the old structure of higher education. Supporters say Measure 87 will allow judges to contribute their wisdom and experience to the preparation of next generation of lawyers and judges attending the University of Oregon and to be paid for it. Measure 87 will allow judges to serve in the Oregon National Guard for pay without concern for a constitutional challenge. Opponents say judges should focus on their courtroom jobs and not be distracted by a teaching job. Judges should not risk being called away from their courtroom for National Guard duty.
We'll now hear about Measure 88. This is called the Oregon Driver Card. It provides Oregon resident driver card without requiring proof of legal presence in the United States. This measure is a referendum, a statutory proposal placed on the ballot by citizen petition with a process with an estimated of 58,291 valid signatures. The financial impact, the cost to provide driver cards to the estimated additional drivers is estimated to be $2,794,802 between 2013 and 15 biennium and $2,677,144 in the 15 to 17 biennium. It's anticipated that this measure will generate $3,610,437 of revenue in the 13 to 15 biennium and $4,333,562 in the 15 to 17 biennium. Revenues in excess of costs will be deposited in the State Highway Fund. The probable results of a yes vote. If this measure passes, persons living in Oregon at least 1 year who cannot provide legal presence in the U.S. may obtain a limited time and limited use driver card if they meet all other requirements. The results of a no vote. If this measure fails, people who cannot prove legal presence in the U.S. will not be able to drive legally in Oregon. Senate Bill 833 was passed by the 2013 legislature and signed into law by the governor. Opponents of the law immediately launched a referendum petition drive and succeeded in referring the measure to the ballot, which effectively blocked Senate Bill 833 from taking effect unless voters approved it as Measure 88 in this November 4, 2014 election. Senate Bill 833 was passed by the 2013 legislature to address the economic and public safety issues identified by a governor's work group on drivers who lack proof of legal presence in the U.S. Currently providing to DMV proof of lawful presence in the country is a requirement to obtain driving privileges. Drivers who do not provide this proof do not have a way to learn the rules of the road, pass a safe driving test, or obtain auto insurance. Untrained and unlicensed drivers can present a hazard to the public. During legislative hearings, issues of road safety, public safety, vehicle accidents, and uninsured drivers were cited repeatedly. The proposal. It directs the DMV to issue driver cards to individuals who pass the written driver knowledge test, pass the behind-the-wheel driver test, provide proof of residence in Oregon for more than 1 year, and provide proof of identity and date of birth. The driver card will look different from a driver's license and may not be used as identification for air travel, to enter a federal building, to register to vote, or to obtain any government benefit requiring proof of citizenship or lawful presence in the U.S. Applicants must pay all the necessary fees to the Oregon Department of Transportation. The charges are sufficient to cover the new costs according to ODOT. The driver card is valid only 4 years, will have a picture of the holder, and be distinctly identified as a driver card as opposed to a driver's license. Holders may not drive commercial vehicles.
So my question is, what are some of the reasons people would vote for this measure?
Supporters of this measure say it's a public safety measure designed to improve road safety and reduce the number of unlicensed and uninsured motorists on Oregon's roads. All drivers must pass a written and driving test and must provide proof of insurance for that test vehicle. They also say that it's a limited measure to provide driving privileges only to eligible drivers. The driver card provides limited term, a 4-year time, driver card that cannot be used as proof of identity, to purchase firearms or to get a commercial driver's license. They also say that Measure 88 gives all Oregonians the opportunity to demonstrate knowledge of rules of the road, pass a driver's test, and get a driver's card, which will help Oregon residents follow the law, improve safety for drivers, bicyclists, and pedestrians. They also say that Measure 88 pays for itself through its fee structure and provides additional revenue to the Department of Transportation to cover the costs of the necessary new employees and administrative expenses. But we should also hear from the opponents, and they say that Measure 88 allows illegal aliens to obtain official state-issued driver's cards that will enable them to appear as having legal status in our state and the U.S. The driver cards may be confused with driver's licenses. This harms the well-being and rights of legal residents. They also suggest that it subverts the U.S. immigration laws, and safeguards are not in place for possible criminal activities such as drug trafficking, and it also does not require background checks. Measure 88 might encourage additional illegal immigration to Oregon by offering official driver cards without proving citizenship. Measure 88, by providing a driver card to persons without legal presence in the state, would make Oregon only the 5th state to grant such a special right. Currently, there are uninsured legal drivers causing serious accidents here, but other states with the new law also have high numbers of uninsured drivers despite this law.
Measure 89, Equal Rights for Women. The official title is amends the Constitution. The state political subdivision shall not deny or abridge equality of rights on account of sex. Initiative. This measure is a constitutional amendment placed on the ballot by initiative petition with an estimated 118,388 valid signatures. Financial impact. There is no financial effect on either state or local government expenditures or revenues. Probable results of a yes vote. If this measure passes, it would add a section to Article 1, the Bill of Rights of the Oregon Constitution, saying, equality of rights under the law shall not be denied or abridged by the state of Oregon or by any political subdivision of the state on account of sex. Probable results of a no vote. If this measure fails, Oregon will retain the current prohibition on laws that treat people differently based on sex, unless justified by specific biological differences. Language explicitly prohibiting sex-based discrimination would not be added to the Oregon Constitution.
Can you tell me a little more what is the background that brings this question up to the voters at this time?
The Equal Rights Amendment has its origin in the struggle of for women's rights that began in 1848. In the years since then, women in the U.S. have gained many rights, including the right to vote, serve on juries, own property, and work in the same jobs as men. However, today, there are still cases where women believe their rights are threatened, especially by job advancement, equal pay, and reproductive health care. The first Federal Equal Rights Amendment, ERA, was written by suffragist Alice Paul in 1923 and introduced in every session of Congress until a new version, also written by Alice Paul in 1943, was passed by both houses of Congress in 1972. This version said, quote, equality of rights under the law shall not be denied or abridged by the United States or by any state or on account of sex. As an amendment to the U.S. Constitution, the ERA needed ratification by 3/4 of the states, or 38 states. Oregon ratified the ERA in 1973, and 35 states have ratified it by 1977. However, it was not ratified by 38 states before June 30th, 1982, the deadline set by Congress. Today, there is still no Equal Rights Amendment in the U.S. Constitution. Oregon's Constitution in Article 1, the Bill of Rights, Section 20 states, no law shall be passed granting to any citizen or class of citizens privileges or immunities which upon the same terms shall not be equally belong to all citizens. There is no specific provision in the Oregon Constitution declaring that men and women should be treated equally. And in fact, Section 20 has not been changed since the Constitution was adopted in 1859, when women had very limited rights at that time. Beginning with a case in 1982, Oregon courts have interpreted Section 20 as providing women and men with equal rights and have held that exceptions can only be made in cases where there are, quote, biological differences, end quote, that might justify unequal treatment, such as providing pregnancy leave to working mothers. Oregon courts have applied the highest standard of strict scrutiny to any case involving sex discrimination and have continued the protections against sex discrimination through case law that is established by previous cases. Strict scrutiny means that a court considers as a policy or law invalid unless the government can demonstrate that it has a compelling interest to justify it. The proposal is that the 2014 Equal Rights Amendment to the Oregon Constitution has 3 parts. The Constitution of the State of Oregon is amended by creating a new Section 46 to be added to and made a part of Article 1, such section to read. 1. Equality of rights under the law shall not be denied or abridged by the State of Oregon or by any political subdivision in the state on account of sex. 2. The Legislative Assembly shall have the power to enforce by appropriate legislation the provisions of this section. 3. Nothing in this section shall diminish a right otherwise available to persons under Section 20 of this article or any other provision of the Constitution. The first 2 parts essentially echo the Federal Equal Rights Amendment that Congress passed in 1972, with appropriate adaptations for the state. The third part of the Oregon ERA was included to ensure that our Constitution will continue to protect other disadvantaged groups against discrimination, even if they are not explicitly identified. Supporters say an Equal Rights Amendment must be added to the Oregon Constitution to protect women against sex discrimination. As the Attorney General's certified ballot title summary states, no current provision in the Constitution expressly prohibits discrimination based on a person's sex. 4 former Oregon Supreme Court justices felt compelled to respond to opposing statements with an open letter saying that the opponents are mistaken. Oregon's protections against sex discrimination are not as strong as they could be because they are the result of case law and because of the exception for biological differences. The former Supreme Court justice, the ballot title, and legislative council also affirm that ERA will not diminish the rights that are currently in the Oregon Constitution for other groups. All citizens would continue to have the same legal rights to protection against discrimination they have now. The former Supreme Court justice said, "We believe that passage of the Oregon ERA will acknowledge the contributions and importance of more than 50% of our citizens by finally providing women express recognition in our state's most important document, its Constitution." Opponents say this amendment is not necessary. The rights of all women and men are already protected by Article 1, Section 20 of the Oregon Constitution, along with the Oregon Supreme Court's application of the highest standard of strict scrutiny to cases involving unequal treatment on account of sex. Amendments to the Oregon Bill of Rights should only be made if they would add protections that are not already guaranteed. Constitution changes should either advance rights that are not already protected or end an injustice permitted under current law. This state ERA does neither. Protecting rights in a piecemeal fashion, especially for purely symbolic effect, may mean that groups with less money and political clout will be left out. The fundamental liberties guaranteed by the Oregon Bill of Rights will be most secure if the rights of all individuals and classes of persons receive the same strong protections. Passage of the Equal Rights Amendment may not automatically guarantee equal rights for men and women any more than the Constitution does now. The Oregon Supreme Court would ultimately have to determine the ERA's meaning.
We now have an opportunity to learn some information about Measure 90, known as the Top 2 primary. This changes general election nomination processes by providing for single primary ballot listing all candidates with the top 2 advancing. It's an initiative that is a statutory amendment placed on the ballot by petition with an estimated 91,716 valid signatures. The Secretary of State Fiscal Estimate Committee concluded that the measure will cost at least $362,642. It also found that additional costs were indeterminate. The probable results of a yes vote. If this measure passes, voting on the primary ballot will be open to all party-affiliated and non-affiliated voters and would allow them to choose one candidate for each partisan office from all qualified candidates, regardless of their party. The top 2 candidates, regardless of party, would then advance to the general election. The results of a no vote. If this measure is defeated, it will mean that the primary system that is in effect in Oregon will remain the same. Some background that brought us to this measure. At the present time, when Oregonians register to vote, they indicate their party preference, or they may register to vote indicating no party preference. Subsequently, according to existing statutes governing the primary election system, a voter who registered with a political party will receive a ballot that includes only that party's candidates, plus the nonpartisan offices. A non-affiliated primary voter will receive a ballot that includes only nonpartisan offices. There are almost 500,000 non-affiliated registered voters in Oregon. Under current law, only major party candidates are chosen in primary elections. Candidates from a minor party are chosen according to party rules approved by the Secretary of State. Candidates not affiliated with any party can qualify by gathering signatures or holding their own convention. Those minor party candidates chosen by signature or convention then appear on the general election ballot. In 2008, Measure 65, also known as Top 2 Initiative, was proposed but was defeated. In an attempt to enfranchise non-affiliated voters and minor parties, the Oregon legislature passed fusion voting in 2009. It provides for multiple political parties to nominate the same candidate for an office. Next to a candidate's name may appear up to 3 party identifications as accepted by that candidate. Now, this measure proposes that to provide for a single primary among all partisan candidates regardless of major party, minor party, or non-affiliated status. All registered voters, regardless of party or non-affiliated status, may vote. The 2 candidates receiving the most votes in the primary would then advance to the general election regardless of the party designation or no party designation at all. The offices affected are Governor, Secretary of State, State Treasurer, Attorney General, State Senator, and State Representatives. If one of the top 2 candidates drops out before the general election, the next highest vote getter would appear on the general election ballot. Supporters say the top 2 will give a voice to non-affiliated voters in the primary, thus reducing extreme partisanship. They also say that it's important that all voters in Oregon be able to vote in a primary election because a more diverse set of voices could create a more diverse legislature. Continuing, they say that this version of the top 2 maintains the integrity of the role for political parties by permitting party endorsements to appear on the primary and general election ballots through our fusion voting. Yes, hi.
So why are people opposed to the measure?
Opponents say since minor party candidates rarely finish in the top 2, these parties may have little or no presence on the general election ballot. Thus, that could lower the overall voter participation. Top 2 would reduce choice in November. Neither candidate would be likely to be from a minor party, and then you could end up with both being from the same major party. It would force many voters to choose between voting for candidates who don't share their values or not voting at all. Opponents also say that Measure 90 is confusing, complex, and may increase game playing with the parties and among the parties.
This is the State of Oregon, Measure 91, the marijuana legalization. The official title, it says it allows possession, manufacture, sale of marijuana by and to adults subject to state licensing, regulation, and taxation. This measure is an initiative, and it is a statutory amendment placed on the ballot by initiative petition with an estimated 88,584 valid signatures. The financial impact. The Oregon Legislative Revenue Office estimates administrative expenses of the Oregon Liquor Control Commission, the OLCC, at $4 million in the first year and $3 million annually thereafter. Revenue after the OLCC expenses are estimated at between $6.5 and $12 million the first year and $20 million per year thereafter. Changes in costs to the criminal justice system are unknown. Probable results of a yes vote. If this measure passes, the Oregon Liquor Control Commission, the OLCC, would be required to license, regulate, and tax the in-state manufacture, processing, and retail sales of marijuana to persons 21 and older beginning in 2016. Current medical marijuana laws would be retained. Probable results of a no vote. If this measure fails, current law would remain. Current law makes possession of less than an ounce of marijuana a non-criminal infraction. Possession of more than an ounce is a criminal infraction. Laws permitting production and possession of cannabis for medical use would not be affected. Background. Cannabis or marijuana was legal in Oregon and in many other states until the 1935 National Uniform State Narcotic Drug Act criminalized the possession of any amount of marijuana. In 1973, Oregon decriminalized small amounts of marijuana, making possession of under 1 ounce a violation, which today is punishable by a presumable fine of $650. The presumptive fine is not the maximum fine a court can impose. The economic and social cost of enforcing current marijuana drug laws in Oregon is often described as one of the primary reasons for legalizing marijuana. According to the American Civil Liberties Union, in 2010, over half of the drug citations and arrests in Oregon were for marijuana use at a cost to law enforcement estimated between $16 million and $83 million. In 1986 and 2012, voters defeated ballot measures that would have legalized marijuana cultivation and recreational use. In 1998, Oregon voters passed a measure to allow the use of marijuana for medical purposes. A ballot measure in 2010, however, was defeated that would have established medical marijuana dispensaries. In 2013, the Oregon legislature passed a law to license and regulate such dispensaries through the Oregon Health Authority. In 2014, the legislature passed a law to allow local governments to impose a moratorium through May 1, 2015 on the placement or operation of these dispensaries within their jurisdiction. In 2012, Washington and Colorado voters passed ballot initiatives to legalize the recreational use of marijuana, becoming the first states to do so. These laws went into effect in 2014. In 2013, the United States Department of Justice issued a memorandum that in effect said that people in states that have legalized recreational marijuana would not be subject to federal prosecution as long as they are following the laws of that state. However, a memorandum does not carry the weight of law, so this more lenient federal policy could be changed at any time. Yes?
Could you tell me what is in this proposal?
The proposal would amend state law to legalize and regulate the growth, sale, and possession of marijuana by persons 21 years and older in Oregon. The OLCC would license qualified marijuana growers, license processors, and packagers, license stores to sell marijuana, set standards, establish the retail price for marijuana, and collect fees. Measure 91 says that in licensing retail stores, the OLCC would be allowed to consider that there are sufficient licensed premises in the locality, or that granting of a license in the locality is not demanded by public interest. Under Measure 91, marijuana sales for recreational use could begin in 2016. Measure 91 allows persons 21 years and older to grow up to 4 marijuana plants and possess 8 ounces of usable marijuana, whether they grow it or buy it. Whether purchased or homegrown, persons 21 years and older may not knowingly or intentionally possess more than 1 ounce of usable marijuana in a public place. The law also limits quantities of other forms of marijuana. OLCC would impose a tax on marijuana payable by licensed marijuana producers at a rate of $35 per ounce on marijuana flowers, $10 per ounce on marijuana leaves, and $5 per ounce on each immature marijuana plant. Revenues collected through the licensing and sales of marijuana would be used to reimburse OLCC for the cost of enforcing Measure 91. Remaining revenue would be distributed as follows: 40% to help fund schools, 25% for substance abuse treatment and prevention services, 15% to the state police, and 20% to cities and counties solely for enforcement of this measure. Supporters say the war on drugs, including the war on marijuana, is a failure that has supported drug cartels and needlessly swept up thousands of people in the criminal justice system at a great cost to law enforcement resources and individuals' lives. By taxing marijuana sales, this measure will generate revenue for the state while reducing the amount spent on law enforcement and prisons. A portion of revenues from marijuana sales will be used for school funding and for drug addiction prevention and treatment. Adults 21 and older should have the freedom to legally buy, produce, and use marijuana as they do now with alcohol. Opponents say any increase in state revenues is not worth the impact on youth and communities from legalizing and increasing access to a mind-altering drug. We should not allow this drug to get an even stronger hold on our society. Oregon is already very tolerant of small amounts of marijuana possession. Increasing access to marijuana would only result in more cost to society, such as an increase in motor vehicle accidents and drug addiction. Legalizing and taxing marijuana sales may have a limited impact on black market sales because those sales would not be taxed and may be cheaper. Marijuana would still be grown and sold illegally. Marijuana operations and retail stores will be a tempting target for criminals.
Our last measure to discuss with you today is Measure 92, and this is mandatory labeling for genetically engineered food. This requires food manufacturers and retailers to label the genetic engineered foods and label them as such. State and citizens may enforce this ruling. This measure would create a statutory provision placed on the ballot by initiative petition with an estimated 118,780 valid signatures. The measure would result in expenditures for startup costs estimated between $550,000 and $600,000. Depending on the assumptions used, costs for enforcement are variable. Therefore, the total financial impact is unable to be determined. Probable results of a yes vote. If this measure passes, labels would be required on raw and packaged foods that are produced entirely or partially by genetic engineered, commonly called genetically modified organisms or GMOs. This would be effective January 2016 and would apply to suppliers, manufacturers, and retailers. The results of a no vote, if this measure fails, existing law, which does not require labeling genetically engineered or GMO foods, would be retained. Yes?
What are GE or genetically engineered plants, and where are they required to be labeled now?
This is important for us to understand the wording here. Genetically engineered or GE plants are food crops that have had one or more genes inserted into or removed from an organism, resulting in a modification. Originally, GE focused on insect resistance and herbicide tolerance. It now also addresses modifications in nutritional value, taste, growing conditions, among other things. Since the 1990s, use of genetic engineering has been growing, and currently the following GMO crops have been introduced: corn, soybeans, cotton, canola, sugar beets, alfalfa, papayas, and squash. Currently, the U.S. is the largest producer of these GMO crops. At issue for Measure 92 is whether GMOs should be labeled. 64 nations, including all members of the EU, India, Japan, China, Brazil, and Russia, have adopted labeling laws in some form for genetically altered foods. In the U.S., GMO labeling is presently voluntary. The U.S. government does not have labeling requirements for GMOs. Developers for GMO products must submit data to the U.S. Food and Drug Administration, the FDA, for foods developed for human consumption or animal feed. The FDA evaluates two data. If they're satisfied with the developer's safety assessments and have no further questions about safety or other regulatory issues, the products can then enter the market. GMOs cannot be present in food that is labeled organic. Efforts to require labeling of foods containing GMOs have been growing at the federal, state, and local levels. Some states have recently passed legislation requiring label of GMOs, including Connecticut, Maine, Vermont. Similar measures have been defeated in California and Washington. This proposal says that it requires the Oregon Department of Agriculture and/or Health Authority to prescribe, enact, and enforce the rules to ensure that food suppliers, manufacturers, retailers label all raw and packaged food that is entirely or partially produced with genetic engineering. This would be effective January 2016. The measure would not include the labeling of alcohol, food served in restaurants, milk, meat, and other food products made from animals fed genetically engineered feed. An action for violations of the law could be brought by the state, or it could be brought by any injured citizen acting in the public's interest. Now, supporters for this measure say 4 things. They say U.S. food manufacturers already label GMO food that distributes to 64 countries. Oregon consumers have the right to know whether the foods they select are genetically engineered so they can make informed purchasing decisions. Continuing, labeling GMO foods would allow for greater transparency and consumer protection. Third, there's mounting evidence that the use of GMO crops has contributed to the growth of herbicide-resistant superweeds and increased the use of herbicides. Lastly, the Consumers Union, the policy arm of the Consumer Reports, has determined that GMO labeling won't increase food costs and has endorsed Measure 92. But if you were an opponent, you would also have 4 ideas. Measure 92 won't give consumers reliable information about which foods contain GMOs and which don't. Some foods would be labeled genetically engineered even if they're not. For example, packaged food containing sugar derived from GE sugar beets or oil from GE soybeans have 0 GE content, yet must be labeled genetically engineered. Some products would have to be labeled to avoid liability if producers could not provide documentation for all of the ingredients. Measure 92 won't tell consumers which ingredients in a product are GMOs, how much of the product is GMO, or the purpose of the genetic modification. Existing nationwide labeling systems already give consumers a more reliable way to choose foods made without GMOs by choosing organic or non-GMO labels. Lastly, Measure 92 would increase food costs for Oregonians, hurt family farmers, and small businesses, and increase costs to taxpayers.
Oregon has vote by mail elections only. Ballots will be mailed to every registered voter before Election Day, which is between October the 15th and the 18th. If someone does not receive a ballot, he or she should call their local elections office. Voted ballots must be received at either an elections office or an official drop box site by 8 p.m. on November the 4th, 2014. Postmarks on that date will not qualify the ballot. Exercise your right to vote. Thanks to our studio audience, our listening audience, and to CCTV for this opportunity to provide ballot measure education today. Thank you.